Hello everyone. My name is Shivangi Tiwari and I am from Hidayatullah National Law University. Today in this video, I'll be dealing with investigation by police. In this video, the topics which I'll be covering are information to the police as to the cognizable offences, FIR, initiation of investigation, police officers' power to require the attendance of the witness, and the evidentiary value of the statements made to the police during the investigation. So, firstly, in India, the first step towards criminal proceedings is an investigation by the police. So, investigation is an exclusive domain of the police and cannot be curtailed in normal circumstances. The main purpose of investigation is the identification of the offender so as to serve him with the punishment to the crime done by him in accordance with the provisions contained under the law of the land. So, according to section 156 of the Code of Criminal Procedure, the police have unfettered powers to investigate into any cognizable offense. The two important steps in the process of investigation are: first is the discovery and arrest of the suspect, and second is the search and seizure of all the material evidences which are essential for the trial before the court of law. So now I'll be dealing with our first topic, which is information to the police as to the cognizable offences. Section 154 of the Code of Criminal Procedure contains provisions requiring the registration of every information relating to the commission of an offence which is informed to the police. The section mandates that every information pertaining to the cognizable offences should be noted down in writing by the police officers in charge or by any other person under his direction. So all such information which is written down should be read out and signed by the person who gives the information to the police. The information which is thus reduced to writing is known as first information, and the report so produced is commonly known as first information report or FIR. So now I'll be dealing with registration of FIR. Firstly, the object of first information report from the point of view of the complainant is to set the criminal law in motion, and it is like the first step taken towards obtaining justice. Whereas from the point of view of investigating agencies or authorities, when we look at first information report, it is the first instance which sets the investigating agencies in motion for carrying out the process of investigation. Now, what is the evidentiary value of first information report? So, the first information report is of very high evidentiary value during the cognizance of an offense or during the time of initiation of investigation about the information furnished under section 154 and section 155 of CRPC. However, FIR cannot be regarded as a substantive piece of evidence, and it can be regarded only as an important piece of corroborative evidence. So now we'll be dealing with the information to the police as to the non-cognizable cases. So section 155 of the Code of Criminal Procedure deals with the information in cases of non-cognizable offences and the way investigation has to be carried out in these cases. According to the provisions of this section, all the information which is received by the police under section 155 must be recorded by them in such books as may be prescribed by the state government under which the police station falls. Section 155 subclause 2 of the code mandates that the investigation related to non-cognizable offenses can never be started by the police without the prior permission of the magistrate who has the power to investigate these cases. Now, how is the investigation initiated? So, according to Section 2, subclause H of the Code of Criminal Procedure, the term investigation includes within its ambit all the proceedings which are undertaken by the police or any other person who is authorized by the magistrate to carry on the investigation with a view to gather the evidences in any case which has been reported. The person who carries on the process of investigation in a criminal case is referred to as a criminal investigator. CRPC contains provisions which direct the police when to initiate the investigation in a particular case, and some of the sections which deal with this subject matter are Section 154, Section 155, Section 156 and 157. So now we'll be discussing about the police officer's power to require the attendance of witnesses. So Section 160 of the Code of Criminal Procedure directs the police officers who investigate a particular case have the power to require the attendance of the witnesses in that particular case. So this section contains the provisions with respect to the power of the police officers to require the attendance of the witnesses. Now we'll be dealing with the evidentiary value of these statements which are made to the police during investigation. Section 161 of CRPC deals with the oral examination of the witnesses by the police and the record and the use of the statements which are made by the witnesses to the police. According to Section 162 of the Code, the purpose and the manner in which the police investigation has to be conducted under Section 161 of the Code shall mandatorily be recorded, and it can be used during the trials. So the main objective behind Section 161 of CRPC is to obtain the information pertaining to the facts and circumstances of the cases, which may be used to substantiate the facts and circumstances of the cases during the trials in front of the court of law. So when a crime is committed, there might be many people who might have been present in the crime scene, and they might be aware of the facts and circumstances of the case. Therefore, the statement of these witnesses are recorded in order to get a clearer picture of the crime and to determine the accused in the case. So any statement or confession made to the police, it's a rule of law that it should never be admissible as evidence. The reason behind it is most of the statements which are made before the police are given under first or second degree torture. Thus, most of the statements made to the police are made with a view to avoid pain and torture meted out to them. Thus, not making statement made before the police admissible in the court of law. So it is in the interest of justice to avoid those statements made by the witnesses to be admissible in the court of law. That was all for today's video. I hope you find this video helpful. Thank you.